Questions are growing about the legality of the death penalty in Alabama after the state executed 45-year-old Ronald Burt Smith last month. Not only did Smith reportedly cough for 13 minutes during his half-hour execution, but there are constitutional questions about whether he should have even been executed in the first place. Joining me now to discuss this case is journalist Molly Vygotsky. Molly, why is Alabama unique when it comes to the death penalty?
Well, Mike, Alabama is the only state in America where a judge has the power to override a jury's recommendation. If an Alabama jury says a defendant should serve a sentence of life without parole, the judge is allowed to throw out that recommendation and impose a sentence of death. And that's exactly what happened in the case of Ronald Smith. He was convicted in 1995 for killing a convenience store clerk during a robbery. 7 out of 12 jurors recommended that he get life without parole, but the judge dismissed their recommendation, and instead he chose to impose the death penalty.
Talk about the mind-baffling drama that played out in the Supreme Court right before Smith's death. What happened there?
Yeah, that was an interesting situation. Smith's attorneys petitioned the U.S. Supreme Court to stop his execution, asking them to consider if the judge should have even been able to give him a death sentence considering the jury's recommendation. And their appeal was based in part on a ruling that justices had made earlier this year in Florida, which had a similar sentencing structure. The U.S. Supreme Court ruled Florida law gave judges too much power, citing the Sixth Amendment, which requires a jury and not a judge to find each fact necessary to impose a death sentence. But justices deadlocked in Smith's case, and they refused to stay. Now, in a separate appeal to the Alabama federal court, Smith had also asked to be executed with an untried one-dose lethal injection method. He was concerned that the state's current 3-dose method wouldn't sedate him enough during the process, based on reports of that happening to other death row inmates. Well, he didn't win that appeal either, and by witness accounts, he moved and coughed when those drugs were administered, and an autopsy is now underway to determine if he died humanely.
In other words, Molly, if I hear you right, this is a prisoner who set out to find out, let me take a choice. I've looked at some of these other horrible deaths by way of other means. Suffering has been incredible, so I choose A. I choose to go with solution A. And that's what he researched, and he decided that. Did I get that right?
Correct, yes, and he wasn't alone. He's one of a handful of inmates that have been petitioning for that same thing in Alabama based on other methods that have been used. The 3-dose method that has been used to execute inmates in states across the country, and similar accounts of what happened to him, to Smith, when he was executed, happened to them. They were moving, they were coughing, there was some indication that they might have still been conscious, and of course that goes against the death penalty, which is supposed to be humane and pain-free, and once they're died, how are you going to ask them if they suffered any pain? So that's exactly why he did not want that 3-dose method. And now there are, of course, no indications that Alabama is even going to reconsider how they do the process of the death penalty anymore. There are no indications that it will change, even though a number of lawsuits are pending. Smith's attorneys had also appealed to the Alabama Supreme Court, asking them to declare the state's death penalty law unconstitutional and reinstate the jury's verdict for Smith of life without parole. But Alabama justices denied their petition, ruled the state's law is constitutional. And in fact, Alabama's Attorney General says judges are better to make that decision.
Molly, thank you very much. This is a story that's going to be continually building over time.